Hello, and welcome to the American Diabetes Association's Fighting for Fairness webinar, Employment and Diabetes. Thank you for being here today. My name is Emma Zagant, and I am the Legal Fellow at the ADA's Legal Advocacy Division. I would like to first thank our Fighting for Fairness sponsor, the Skadden Foundation, and I would like to thank our co-presenters, Brian East and Dr. Timur Durrani, who will introduce themselves shortly. Please note we will save time at the end for a Q&A, so please put your questions in the chat box and we will do our best to get to them at the end. If you are seeking CLE credit, I will read off 2 codes during the presentation, so please listen carefully and write these down to submit in our attendance form, which will be distributed at the end of the webinar. Finally, please note that this presentation does not constitute legal or medical advice. With that, I will pass things along to Brian and Dr. Durrani.
Thanks, Emma. Brian East here. I'm a lawyer at Disability Rights Texas in Austin. And I wanted to start by giving an overview of the applicable laws here. So we're talking about representing and protecting people with diabetes in the workplace. The first law that we think about is the Americans with Disabilities Act. So next slide, please. So the ADA protects people, Title I protects people from disability discrimination in employment. And there's a couple of main points to point out, main things to point out. The first is that diabetes is almost always a disability under the ADA. And that is confirmed by the regulations put out by the EEOC at 29 CFR section 1630.2 J3. So that lists several predictable assessments that, in light of the required analysis under the ADA, will virtually always be a disability. And one of those listed is diabetes. I will say that this used to be a big fight before the ADA Amendments Act. It's not as big a fight anymore, but there are some things to think about if disability is not stipulated or admitted in terms of what to do once you get to court to show disability. But we can start off by thinking that diabetes is a disability and therefore the ADA is going to apply. Next slide, please. Title I of the ADA is the employment provision. It applies to employers with 15 or more employees. It also applies to unions in certain circumstances, even if they have fewer than that. And it applies to employment agencies, regardless of their size. There are other rules regarding the employers that are covered. And a good source for things like that, or general provisions of the ADA and similar laws, is the EEOC's threshold issues document. So you can just Google EEOC threshold issues and you'll come up with it. And there it answers a lot of questions about who's covered. In general, the general rule is the one set out in 42 USC 12112A, which is on the slide here. And it says that no covered entity, employer, shall discriminate against a qualified individual on the basis of disability with regard to basically all aspects of the employment relationship: the application, the hiring, advancement, or discharge, compensation, training, and other terms, conditions, and privileges of employment. There is another part of 12112 that is not on the slide, but Part B gives some specific protections under Title I. They include the obligation to provide a reasonable accommodation, prohibition against discrimination based on someone's association with a person with a disability. So, for example, can't discriminate against an employee because their child or their spouse has diabetes. And it also has restrictions on qualification standards that applicants must meet in order to get hired. So 12112 is sort of the key provision in Title I. Next slide, please. The other law, the other federal law that's important here is the Rehabilitation Act of 1973. And we're talking about is the anti-discrimination provisions in there. So this is a big law. It funds voc rehab programs. It does a lot of things. But the sections we're talking about really are sections 501, 503, and 504. 501 protects federal employees from disability discrimination. 503 protects employees of federal contractors. And 504 protects employees of any entity that receives or disperses federal financial assistance. The substantive terms of the Rehab Act, in terms of what's discrimination, what is required, what is prohibited, those are the same as the ADA in general. But the procedural aspects of the Rehabilitation Act, the deadlines, whether exhaustion is required, some of that varies. But we can, start off thinking that we have this body of law, the ADA and the Rehab Act, that are pretty consistent and that cover between them a lot of employers. Last thing I'll say on this slide is that there are state and local laws that may also protect people with disabilities, and this webinar is not addressing those. We're really talking about the federal laws. Next slide, please. Another law that's important here is the FMLA, Family and Medical Leave Act. This is not an anti-discrimination law, but it does guarantee a certain amount of leave, which can be unpaid per year for someone who has a serious health condition. And as this slide points out, that can include diabetes. The key point to note here is fewer employers are covered by the FMLA than are covered by the ADA, and fewer employees are covered. So there's a potential difference there. But the key thing the FMLA does is protect the right to take leave for certain covered employees. Next slide. So the federal regulations enforcing the ADA are at 29 CFR Part 1630. And if you look at the regulations under Section 504 or Section 501 of the Rehab Act, there'll be a provision that says we follow the same standards and we follow the same regs. So those regs at 29 CFR 1630 are useful under either law. And they give some detail to what is in the statute, although the statute itself in this area is pretty detailed. One of the regulations, though, creates a defense for the employer if something is, if, for example, an accommodation or a hiring is prohibited under another more specific federal law or regulation. So where we see this most often is with regard, for example, to an over-the-road trucker who must have a CDL and therefore has to qualify for a CDL under the Federal Motor Carrier Safety Administration's requirements for people who use insulin, for example. So those are an addition. And so if you fail to do that, the employer may have a defense. And if there is a dispute about whether you have satisfied that requirement, whether the doctor's note was accurate, there is a mechanism for dealing with that. And you kind of have to go through that mechanism. Similar situation for pilots. There are requirements by the FAA. There's a medical certification requirement. And so you have to satisfy those. And if there's a dispute, you'll want to go through that dispute mechanism and not just rely on these more general anti-discrimination statutes. So I think that's all I have to say as a general proposition about the laws that we're talking about. If anybody else has any comments or questions, fine. And I know we'll be taking questions at the end, but if not, I will move on to a general discussion about accommodations in the workplace. Next slide. Yeah, thank you. So as I mentioned, the ADA specifically requires reasonable accommodations for people with disabilities that need them, and that's at 42 USC 12112 B5. And B5A requires accommodations. B5B prevents discrimination because of the need for an accommodation. A little bit different, but both of are important. The regulations in the addressing accommodations are at 29 CFR section 1630.9. They don't add a ton of detail here, but the sort of general overview is straightforward enough, and the cases are very well developed in this area. There is a defense here, which I'll briefly mention, and that is undue hardship. So an accommodation might be otherwise reasonable on its face, but it might be an undue hardship in a particular circumstance. So we can circle back to that. The accommodation process is supposed to be an interactive one, and it normally starts with the employee requesting a reasonable accommodation and notifying the employer that they have a disability, in this case, diabetes. So sometimes the employer already knows that. The employer may be already giving accommodations, but in general, we recommend that you disclose your disability and you make a specific request for a reasonable accommodation. It can help to say what the accommodation is. That isn't necessary that you have it all figured out, but with regard to diabetes, where the accommodations are often pretty common, it may help to explain at the outset what it is you need. So the employer normally doesn't have to do anything until they get that request for an accommodation. There are some exceptions. If, for example, the condition is known or obvious to the employer, there may not need to be a specific disclosure. Or I should say, if the condition and the need for accommodation is known or obvious, then nothing more may need to be required. It's also generally understood that if you're already getting an accommodation and the employer is revoking that for some reason, which might happen, you don't normally have to make another specific request because you already did and went through that process. Also, the disclosure and request doesn't have to be using magic words and doesn't even have to be in writing, but we do recommend that it be in writing and that you use magic words, or that your client uses magic words like reasonable accommodation or ADA or something like that. It can also be important if you're asking for leave that you specify you're asking for reasonable accommodations and not just FMLA. Some courts say one isn't good enough for the other. And so you want to be clear with the employer what thing it is you're asking for. So once the employer gets a request, both parties are supposed to engage in this flexible interactive process. And the one that doesn't do it right is often sort of held to be at fault. So the employer who ignores the request or just says no and won't talk about it further, that's not normally engaging in the interactive process in good faith, and they may be in trouble. Likewise, the employee who, in response to a request, can I get something from your doctor confirming you have diabetes and that you need this thing, says no, I'm not going to give you any of that stuff. That may not be participating in good faith in the interactive process. So it's important that both parties do that. And then once that process goes through, then there should be an identification of a reasonable accommodation and implementing it. Last things I will say here is that the employer doesn't have to give the preferred accommodation. They just have to give one that's effective. So sometimes there's more than one that would work. The employee may prefer the particular one, but the employer prefers a different one. And if it works, that's okay. If it doesn't work, it's not. And that last point leads to my final point on this slide, which is the accommodation process is an ongoing one. It's continuing. And so if, for example, something is tried out and it no longer works, then the parties are supposed to keep engaging and going forward. So it isn't you do it once and you're done. So next slide, please. Examples of common accommodations in the context of diabetes. So the most common ones that we see are a break to allow someone to test or to take medication or look at medical technology, et cetera. And so an opportunity to do that. So sometimes that requires a certain place to do it. It will require a few seconds or minutes to do it, so some time to do it. Occasionally, it can require a place to store medication or to store food if that's part of the diabetes management that the individual is doing. So all that can be important, generally very easy, and pretty well understood in the case law. Those are pretty straightforward accommodations. Last couple of bullet points here. One is modification to no-fault attendance policy. I'm going to broaden that out just a little bit and say that leave as an accommodation can be required because someone needs a certain kind of treatment or because someone has manifestations of diabetes in various organs or in various parts of their body and need treatment for that. And so they may need leave. And this modification of no-fault attendance is a type of that. So some employers have this no-fault policy. You have X number of days per year to take off for any reason you want, sick, vacation, personal, whatever. But after that, you're in trouble. And someone may need more than the standard, and that can be a reasonable accommodation. The last bullet point on this slide is about modified work or lunch schedule. So again, access to food or other products to address a person's sugar is part of it. And so the lunch schedule may be important. What I've mostly seen in the modified work schedule context is someone who has a very difficult schedule, a rotating schedule, or a split shift or something, where it makes it really difficult to manage their diabetes because the schedule is so uneven. And so the accommodation request may be some sort of fixed schedule or some alternative schedule. Next slide, please. So I mentioned that some people have complications from diabetes. And we see on this slide on the left that complications can be affecting the heart, the kidney, nerves, eyes, hearing, etc. And those kinds of complications may lead to other kinds of accommodation need. Those kinds of complications may lead to different kinds of accommodation needs that are perhaps less standard. So we have some examples on the right-hand side of this slide: a stool or access to a chair for someone with an amputation or other mobility complication, access to an elevator, similar, access to screen readers, large screens, and other assistive technology for someone with eye disease. I will note that the Job Accommodation Network, which is federally funded and online by Googling JAN, J-A-N, has a very detailed paper on diabetes. And therefore, if you put JAN diabetes, you'll come upon it pretty quickly. And it has a long list of the more standard accommodations that we talked about, but also accommodations for complications in various body parts that's on this slide. Next slide, please. So this is about technology in the workplace, and this becomes important because more and more people with diabetes are using sophisticated technology to manage their diabetes, and that can be insulin pumps, CGMs, often using cell phone applications to help them with that. And that could be a problem if their employer has a no cell phone policy, doesn't allow you to access the web, you're in a secure facility where that's not, that the kind of traditional access is not permitted. And so what do you do here? So this is coming up in certain circumstances because technology is much more common. And so there's some suggested workarounds here that include using a secure device and having the app downloaded onto that. Otherwise, using Bluetooth instead of internet access. There's various other ways around it. I note that the ADA website has a paper, I think it's still up there, called Your Job and Your Rights. And then something about diabetes technology accommodations in the workplace. And it goes through some of this in a little bit more detail. That's my sort of overview of the laws that we're dealing with, what they say is in general, and the accommodation piece, which is very important. So I'm going to stop there for now.
I will now be reading off the first CLE code. The code is 1676. 1676.
All right. Thank you, Brian. Thank you, Emma. Hi, everyone. My name is Timur Durrani. I'm a physician. I'm an occupational medicine physician at the University of California and a professor of medicine here. I'll be going over some of the safety concerns that tend to come up. A lot of our role in the occupational medicine realm is working with workers and their employers and trying to find restrictions or accommodations that will allow for workers to continue working while allowing the employer to get their job done. And so we'll go over some of the safety concerns that we often hear in that realm. Next slide, please. So one of the things, I think, if you look at that second bullet, is the thing that comes up the most in diabetes that I hear is concern for sudden incapacitation. And so on the first bullet, I think we recognize that just by having diabetes does not necessarily put someone at a specific risk. However, there is often this concern around someone, let's say, becoming hypoglycemic, having a low blood sugar, and suddenly being a risk to themselves or others. And that tends to be very much an individualized risk. It's not something that is the same across the types of diabetes or across a population of people with diabetes. And so we tend to see people who are at risk for sudden incapacitation are generally a much smaller number of people who have diabetes, and it tends to be the same people. And so the majority or many of the people who have diabetes don't experience these severe sudden incapacitations due to loss to low blood sugar. And so one of the things that we then look at is trying to individualize and understand who is at risk and then what risks do they pose. So if do they pose a risk to themselves only? Do they pose a risk to others, equipment or public health and things like that? And then work with risk assessment and provide some level of instruction to them and hopefully to their employer on how to mitigate those risks. From a medical perspective, understanding what those risks are, particularly that there's a small group of people, it tends to be people who have had it repeatedly in the last year or so. Those are the risks that we are trying to assess. Just having diabetes or just using insulin on its own is not necessarily a risk factor, a high risk factor or on its own. And so we use that from an independent, sort of use as a individual evaluation. One of the things that Brian had talked about was these continuous glucose monitoring devices. And instead of having, let's say, poking your finger and then looking at blood sugar, these things look almost like maybe a small iPhone or what the old days of the pagers look like, and can continuously monitor sugar. And the reason we like those is that they tend to decrease the risk of people having these concerns around sudden incapacitation. Next slide, please. So I used some medical terms there, this hyperglycemia and hypoglycemia, and they're both aspects of what we see in people who have diabetes, and it all revolves around trying to manage blood sugar in the blood. And so hyperglycemia is something that we see over time and affects people over time. It generally does not cause a sudden incapacitation. So although it's problematic for a number of things from a health perspective, and Brian had described a lot of those from effects on the eyes and the kidneys and so forth, it's generally not a concern from a sudden incapacitation standpoint. Hypoglycemia, in contrast, and again, not as common as we see with the hyperglycemia, can occur, although not that common. When it does occur, it can be in a range of anything from someone who can notice, and most people can sort of tell when they're starting to feel this, or to a point where they need some assistance. When we are trying to evaluate that for patients, that is part of the evaluation to try and determine how frequently does this occur, how much does someone have the ability to respond to this, and how would they go about do this, and in what setting would this be? Would they be in? And so I think the bullet slides that you see there, the majority of people with diabetes who use insulin can recognize their warning signs and are not a safety threat is important. Next slide, please. So I think the questions that we consider are, what is the safety concern in regards to the person's job? And so if we have someone who's working in an administrative fashion and really is not posing a risk to themselves or others or equipment and things like that, that's one level of trying to understand this risk, as opposed to, let's say, someone who works at heights or with power equipment or things like that. And so that's the first thing that we try to understand is what is the actual job function and what is the risk to that person. And the second is, what's the appropriate evaluation? Some people will have one hypoglycemic event. That doesn't necessarily keep them from working or doing that work. And I think it's all about understanding when and how and what have we done to reduce those risks. And then are there reasonable accommodations to mitigate those risks? Brian had described a number of those reasonable accommodations. And so I think all of those are possible at trying to mitigate things like particular thing that we were about sudden incapacitation. And so one example that comes up often is somebody who may be driving for their job. And so the things that we go through to try and understand and look at their risk are things like, are they able to detect and appropriately treat their hypoglycemia if they have it? When was the last time they had one of these? Was it multiple times in the last year, or they haven't ever had one or haven't had one for several years? And then do they have other complications? Are there things where they have, let's say, loss of sensation or things like that in their feet? All of those things are things that we use as an example to try and understand the risk in someone, let's say, who's a driver that may have diabetes. And then there are a variety of different accommodations, as Brian described. Some people who are able to test their blood sugar nearly continuously are at a lower risk of having these events. But some people may need to test every hour or every few hours. So they need breaks and locations to be able to both check their blood sugar, maybe administer some insulin, or have some food or water to try and help their body regulate their sugar. And so those are all methods of restrictions or accommodations that can be used to help mitigate those risks. Next slide. I think I'll turn it back over to Brian.
Okay, great. And before I address confidentiality, I was just going to say that there are some safety defenses in the ADA for the employer. The main one here is the direct threat defense, and it's defined at 29 CFR 1630.2R. But it sort of goes through the factors that Timur has already described. And I think, he's given us a really good understanding of how it works practically in this case. Okay, so with regard to privacy and confidentiality, the ADA itself and because the Rehab Act tracks the ADA, the Rehab Act 2, both have certain protections for confidentiality of medical information. And the general rule is that the general rules are, number one, the employer isn't free to tell coworkers about the disability that an employee has, including diabetes. There is a little bit of a gray area in the case law about what happens when the employee shares that information just voluntarily. They're not asking for an accommodation. They're not doing it for any particular reason. They're just telling their boss or their coworker about it. And the EEOC says resharing that information violates the law, but there are some courts that say that's different. Maybe that doesn't violate the law. But in general, employer isn't free to tell others. And the second part of that is all the medical information that the employer gets is supposed to be kept as a confidential medical document separate from the personnel file, for example, and shared only with those who have a need to know. So often the employer starts off thinking, well, the supervisor has a need to know, but actually the supervisor doesn't really need to know the details or even the condition. They can be told by HR, there has been an accommodation approved and it is this. And that should be enough in many cases. Not to say the supervisor never needs to know, but this is sort of an important protection, and one that has been sort of guarded by the EEOC in the statute and the regs and in the case law. So the citation for this material is at the bottom of this slide. I'll also just mention that the ADA and the Rehab Act also prevent employers from asking about any of this of a job applicant before they make an offer. So they're not supposed to be asking about any disability, including diabetes. After they make an offer, they can ask about it. And then if they don't ask about it or they don't know about it, and the person is working and they need an accommodation and disclose it, they can ask for information there. And often a doctor is brought into that process by the employer or the employee or both. And I know, and we're going to get to that now. So I'm going to pass it back to Timur.
All right, thanks, Brian. So I think the next piece we'll be going over is working with healthcare professionals and best practices. And so I can give you some thoughts on how this works for us. Oftentimes we will have a patient or a worker come and say, that they need to communicate to their employer something. And oftentimes we'll find that in workers or patients don't fully understand the interactive process, how it works with their employer and so forth. And oftentimes a lot of our physicians don't understand that. And so what we are looking for is sort of clear guidance on these kind of things. And so, in terms of how do we describe essentially what is it we're looking for to help the patient or worker continue with their job with some samples around restrictions and accommodations. If you look in your handout on page 10, you'll see a sample letter there that has just about everything, and you could go and provide that to a healthcare provider, and then they can take pieces out. So for example, there are things in there like, here is my patient and they have diagnosis X. Most healthcare providers probably won't feel very comfortable about releasing that unless they think they need to. So that can be removed. My experience is that oftentimes we rarely reveal the diagnosis, but there are times where HR, the employer, someone can sort of figure out the diagnosis, or they work backwards from it, which is, there's not much we can do about it, but we don't generally hand that out unless we need to. In some of the discussions I've had with other attorneys, one of the things I've been reminded of is to provide some flexibility, if we can, to the employer around the restrictions and the accommodations. And you'll see some of that language in the example sheet. And really what we want to remind providers is, please don't make this a quote, fire my patient letter. Because if the healthcare provider is too stringent and doesn't allow for any flexibility, it may turn out that the employer can't, or at least thinks they can't, accommodate that. And so providing some flexibility is helpful, I think, for both ends. And then finally, I just want to remind you all that if you are able to join the attorney listserv, you'd be able to hear that's provided by the American Diabetes Association. You can gain access to healthcare provider referrals that could help your clients. Next slide, please. And so I think a couple of things, and Brian, I'd be interested in some of your thoughts here. You know, when we look at the diagnoses, rarely, as I said, do we ever really have to, you know, do I reveal that? And if we do, it's a conversation with the worker or the patient to say, you know, do we think we need to release this? What I do think is helpful is trying to describe what things need to, you know, what major life activities may need to be accommodated. And again, sometimes people can sort of back calculate trying to figure out what that is. Well, my worker or patient needs a break every hour. They need a private space. They may need access to a mobile phone. They may need access to a sharps container or food. Somebody could probably back calculate some of those things. But again, I think the important piece, particularly for healthcare providers, is that we don't always realize that the person on the other end may not be a healthcare provider, may have no healthcare background at all. We may be writing it for the HR person at a construction company. And so we have to write it in such a way that it can be understood. And so that reminder, I think, is helpful. Brian, I'll stop and see if you have any thoughts or suggestions around that.
Yeah, so I think there is sometimes a difference between what you do as an occupational medicine specialist and what the employer is seeking, appropriately or otherwise, or what an endocrinologist might provide. So occasionally I see letters from the employer to the client or to the client's provider that are really asking about, is this a disability? So they're really asking that sort of legal question. You know, I get that they have diabetes, they say they need an accommodation, but is this a disability? And so there are times, I think, when the employee, the patient, does want their doctor to disclose a diagnosis or whatever. And I often see them, I often see the letter to the form to be filled out as saying, you know, which of these major life activities is substantially limited. And when you look at this be the third bullet point here, the major life activities listed, these are in the statute, there's others in the regs. But often these days, especially with good management techniques, it's easy for the doctor to think, well, they're not really limited in any of that. What they should be asking is, are they, if without regard to mitigating measures, in other words, if they were not taking medication, not taking insulin, didn't have access to any of that, and if we look at the condition in its active state, would they be substantially limited in these things in the third bullet point or the things in the second? And endocrine system is listed here really in large part because of diabetes, and to show that a substantial limitation in endocrine functioning is a disability. And so if they asked it correctly, you know, I think any doctor who's gotten permission to answer this question by their patient would be able to say, yes, without access to any mitigating measures, it's going to be bad and you're going to have lots of limitations. But so the forms are sometimes confusing and frustrating. But I think to your point, Timur, you were telling me how you normally aren't asked to and don't get into the diagnosis. You're really just talking about the limitations. and what can be done to address them. But I do think sometimes it comes up when, they're asking the endo doc, to tell us more about this person's diabetes. So I think it is an interesting thing. And I do think, we lawyers who have the opportunity to interact with medical providers, I think, by pointing out that endocrine functioning is one of the listed bodily activities that can be substantially limited. And because we're supposed to be looking at it without regard to mitigating measures, when the question is this really a disability that substantially limits something? Yeah, in that context, it is. Virtually always, as the EEOC says. But that doesn't mean, they can't function at work. So this part for me is a very difficult one, because the employer is often asking for inappropriate stuff, saying it wrong. The doctor is very busy and doesn't have time to mess with lawyers, or at least doesn't want to if at all possible. So I think this can be frustrating, but I think there's some really important lessons in what Timur said and in the sample letter. I think that gives us some good guidelines going forward.
Thanks, Brian. I think the other thing as a physician that would be helpful is we rarely understand what it is our patients or workers are doing unless we spend, if you're an occupational medicine doc, we generally know we go out to workplaces, we walk catwalks, we've done a variety of things with different workers. But if we're a busy primary care provider, a busy endocrinologist, they may not, maybe a while since they've been out to a construction site. And so oftentimes I think one of the things that's really helpful is just understanding what it is this person does. And sometimes a picture's worth 1,000 words. I had a patient the other day just show me exactly what it is their job was. And from that picture, I could see, wow, they had to bend over, lift something up, probably 20, 30 pounds, twist, put it onto a table, and then push it. And so suddenly I had a much better understanding. And so sometimes we get employers who will send over a 3-page, 8-font, single-spaced job description, which doesn't really mean anything when we're trying to get through the day. And sometimes, we'll understand what does a firefighter do? We may understand what that is, but sometimes there's pretty technical terms, job descriptions. And so anything that will help the provider understand what it is that they have to do on a day-to-day basis, and then understand how that matches up to the major life activities, I think can ultimately help the patient and the worker, and the employer to get to a place where the worker is able to work and satisfy the needs of the employer. Great. Thank you. So some resources and some future opportunities. There's a few things that we wanted to point out to you that may be a useful resource. One, as I mentioned, is there's the Legal Advocacy Network listserv. That will get you a variety of things, including access to experts and referrals, and other referral services that would be helpful for your clients. The link there to the use of the ADA standards of care in diabetes, I was provided this some years ago by one of my colleagues who's an attorney, and found this very helpful. And I think that can be used, also provided to other healthcare providers. For example, if you have a worker who's a driver, there are things on there of how to work with drivers who have diabetes and so forth. And then the last is looking for other attorney resources there, which I'd refer you all to, but I know there's a link there for other resources for attorneys. And then just to let you know, we have a couple of other webinars coming up on the Fighting for Fairness. So on the 19th, you'll see the rights of people with disabilities in public accommodations. And then on the 26th, diabetes discrimination case law in review. And the link is there for you to be able to register and obtain CLE credit. And with that, I think I will turn it over to Emma.
All right. Yeah, thank you to both of our speakers. We'll jump into the Q&A with the remaining of our time. And please remember to stick around to the end. After the Q&A, I will read off the last CLE code and give everyone that form to fill out. So the first question I have is, what's the best way to educate employers who might have blanket misconceptions about diabetes and safety risks?
I'll take the first part, I think. The one that I see the most is the word diabetes. Depending on when people had grown up and where they grew up, they think of diabetes as, I think nearly equivalent to sudden incapacitation. And so oftentimes, well, that means this person can't work here, or maybe they can't do a variety of different things. And so I think the explanation around that being quite rare, and really diabetes is a lifelong condition that, most people with appropriate medical management do well. And so explaining that it's really not this, again, depending on when they heard about it or when they first saw it, is not something that somebody can't work with. It's really a matter of understanding it's a condition that a large portion of the population has and lives with and can do well with.
Yeah, I think that I agree with all of that, of course. And I think there are some resources, including the ones on the earlier slide at the ADA, American Diabetes Association, that are useful in this way. The Jan article that I mentioned on diabetes might also be useful. Obviously, a letter from a treater or a diabetes educator could be useful. But I think about sort of a famous case that was here in Texas, where the employer's doctor testified that someone with diabetes can't be safe anywhere outside a padded room. That was his actual testimony. They lost based on that testimony, but that was sort of that attitude. And now, when we see the technology has advanced so far, the continuous glucose monitors, I know some of them have alarms on them to let someone know when they're going low, if they can't already feel the symptoms. So there's just so much better management techniques that we have now in technology that it really makes no sense to think of diabetes this way for 99% of employees with diabetes. But yeah, it's a good question.
All right, thank you both. The next question is, can you talk about if you need an expert to prove diabetes is a disability in court? Brian, this question might be more for you.
Yeah, so we talked about how diabetes is virtually always a disability. There's certainly a lot of cases that are consistent with that. But I think the key thing to remember is that if you are in court and the other side won't admit that diabetes is a disability, or won't stipulate that for purposes of this case it is, that may be because they're actually fighting you on it, or maybe they won't admit it, or they won't contest it, but they also won't admit it. So that means you still have to prove it in those cases. And what you have to do kind of varies. But one of the things you want to make sure you can get in is that there is a diagnosis. That could be an expert live. It could also be medical records if you get them admitted through a business records exception or something like that. And then you may need testimony about what would happen if the person didn't have access to insulin or other medication. And so sort of, because that's the way to get coverage. So the answer is you could need an expert in cases like this where it's pretty good evidence that it is a disability. I do push to get an admission that it is a disability, so we can just not have to worry about that part. But there are times when they won't agree with that. And so it just depends on what I can show. I can certainly show manifestations for my client, what my client has to do to manage it, their technology and all that kind of stuff. But if I have to show that their condition substantially limits the endocrine system, if they did not have access to these management techniques and medication, I may need an expert, or I may need a deposition of an expert, or to get past summary judgment, the declaration of an expert. So I think it depends. You shouldn't have to need it. I think Congress didn't think you would need it, but I think the reality is sometimes you might need it. And in the material, I think that was that accompanied the statement that accompanies this, there is sort of a good case and a bad case, if I'm remembering correctly, if that's in this document. But there is a bad case where they said the plaintiff, they didn't say diabetes is not a disability. They said the plaintiff didn't show that their diabetes was a disability. So that can happen. So it's worth preparing for. I will also say that having been on the ADA listserv for lawyers assisting people with diabetes and having those connections with medical providers, that has been really useful to me. I've gotten excellent reports from some of those doctors in my cases. I've used those to settle cases. So yeah, really valuable.
Okay, our next question is for both our speakers. How do you approach employers who want to equate A1C with safety risk?
Oh, interesting. Maybe I'll take that one first. I would say that generally it's a misunderstanding from an employer to need that information because about the only person who's really looking at that is their primary care provider, whether it's their endocrinologist or their primary provider. And I think it's probably a misunderstanding that the A1C is somehow used as a singular risk assessment. And so that would be the way I would respond to that rather than releasing it, because essentially we'd be releasing a number that they wouldn't know, generally wouldn't be able to interpret other than sort of Googling what they think that means. But it doesn't correlate to risk. And so I think it would be a conversation to explain this is really not the metric, although convenient in sort of thought that if there was a single metric that would somehow relate to risk, it doesn't, and honestly has more to do with how well is somebody managing their diabetes, which is a good health question, not one for an employer, really more for their primary care provider. So I think it would be a conversation for them to understand that, which I can imagine could be if we had an employer who was asking that, they clearly have an assumption, and that could lead to some level of misunderstanding. But I explain that it really is not necessary and is not a measure of risk would be how I would respond as a physician.
And Emma, you may know the answer. My recollection is that in the diabetes standards document or in the position statement on employment that I think will be coming out this year, I think it does explain how the A1C, exactly what Timur said, that is not useful as a prediction of problems at work. It's just this snapshot that can be helpful in in doctor-patient discussions, but it doesn't have any value here.
Okay, I will move to, I believe this may be our last question. How should attorneys advise their clients to address the issue of unauthorized medical disclosures in the workplace, and what's the practical effect?
Yeah, so I've had this discussion with Timur before about, and he sort of mentioned that we start off as occupational medicine doctors not even giving the diagnosis. We're really looking at other stuff. But the main thing that I want to tell my client is that the doctor still is only supposed to release what you authorize, and you don't have to authorize a blanket release. So sometimes the employer says, get your doctor, give this to your doctor. sign it and give it to your doctor, or sign it and give it back to me and we'll give it to our doctor. And it says, I release all my medical records for any condition at any time, ever, anywhere. And there's no support for something like that. So first is, make sure that the release that the employer wants you to sign is appropriate, is about the condition, sort of limited in time, perhaps addressed to a particular doctor. But doctors, so if that's going to the employer is often going to reach out to somebody, perhaps the primary care doctor, and say, hey, I've gotten permission. So I often tell the client to remind the doctor that I have authorized you to talk about this or give records, but only these things, only for the last 3 years and only related to my diabetes, or whatever it is. So I think it's helpful because the doctor gets this release, they think they're supposed to do it. The employee their patient has signed it. And so we want to remind them that it is limited if it is. And we want to remind the employer that they should be asking, for targeted information and release and not blanket stuff. I don't know if that answered the question. And Timur, would be interested in your further thoughts.
One of the things I think, particularly if it's the first time for that patient and the physician, is I think, or the primary care provider, is I think it's worth a face-to-face at least once and maybe twice. Oftentimes the healthcare providers are provided a form to fill out with not a whole lot of context. And so they sort of, I filled this form out before, and they get all kinds of forms. Fill out a form to get cleared to go to school, fill out a form for a job, fill out a form for workers' comp. There's a variety of different forms. And so if it's the first time, I think it's worth a face-to-face, because I think that allows, although it's hard because you have to take time off work and go see the provider and so forth, it allows for understanding of the form and understanding of the job, which I think would help expedite, which is oftentimes some of the things I see 2 or 3 sort of effects down the road, where I didn't understand what the employer was asking. I didn't know what the patient wanted. I tried to do my best. And so I think that is one way to help with that. I think the other is, and I've done this, is if it's really if the employer is really that interested, and if the employee is able, is to have the 3 have a phone conversation. So maybe it's the patient and the worker, or the patient and the doctor in their office, and calling the employer. We know, doctors' offices are busy and so forth. So maybe the appointment's at 11, but they can't get on to 11:30. And so having the employer be flexible around that, because I think that can help shortcut a lot of what was I allowed to disclose, what were we looking for, and that kind of thing, particularly on the first one. After that's happened time or again, it's a form that just needs to be updated, may not need that. But I think that helps with that, because if when I've had patients in the room as I'm talking to the employer, I'm sort of self-editing what, I know I'm not going to give a diagnosis, but I say, hey, look, they need help with push-pull. They can't do X, Y, and Z. And we sort of get almost a mini interactive process going ideally in an efficient amount of time, because the forms and so forth can get lost in the shuffle.
Okay, thank you to our speakers for sharing their expertise. I think we're now gonna wrap up and share the final CLE code. Thank you everyone who's attended, and we hope to see you at the next Fighting for Fairness webinars. The forum will also be put in the chat, but the last CLE code is 6034. I'll leave the screen up for a little bit so people have a time to scan the code. Thank you again, everyone, and have a good evening.
Thanks all.
Thanks, bye.